Okay, we're going to get started. Ready? Are we ready? Thank you, Heavenly Father, for allowing us to meet here. Please open up our minds and our hearts to this law, because all of the law is your law. We ask this through your Son, Yahushua. Amen. Pete, you got something there?
Yeah, this is Pete. I wanted to... I've been doing a lot of faults and defaults and dishonors and protests, and we're doing a love dance with the IRS, and they send me letters on something, and they send my wife letters on the same thing. Then a few days later, we'll get another letter with a few cents more of interest due on it, and I just got paper coming and going left and right. Caleb has been doing my third-party witness, mail receipt, and mailing for me. And you get, this is just a suggestion to people, you get so many pieces of paper floating around that in the last month I have taken to putting the certificate of mailing. I send them out originally on the person who gets the mailing gets two separate sheets. They get a certificate of mailing, which is the thing that just has the addresses on it, and then they get my folded certificate of service, which is folded inside an affidavit of the certificate of service. And when I make copies then, so the person who gets the original gets a separate piece of paper, one for the service and one for the certificate of mailing. But all copies and what I retain for my own records, I put on opposite sides of the same sheet of paper, so that there's a certificate of service, and then on the other side of it is the certificate of mailing, physically on the other side of the same piece of paper. And then that certificate of mailing gets the 90-cent or whatever stamp, machine stamp on it, and then you keep the cash register tape from the post office and you have the signature. And then physically on the other side of that paper is the certificate of service copied, and then that becomes an affidavit of certificate of service. In other words, that gets notarized. And so that notary seal punches through both pieces of paper. So when you have it in your files, you can tell whether or not you actually sent something, because I don't know that you've ever gotten into this, but you do drafts and then somebody says, well, this isn't good and that isn't good, and you change it, and pretty soon you get confused about what was a draft and what was the real thing. And this has been helping me to put the service and the certificate of mailing on opposite sides of the same piece of paper, because then, for one thing, the party who does the mailing has the assurance that when he's signing that and notarizing it, on the other side is the cash register tape and the postage, so he knows that he's actually given an affidavit on something that really happened, and you don't get caught with your pants down of giving an affidavit on something that was never sent out. Anybody got any questions on that or comments on how to control your paperwork better? Okay, I want to talk on another issue then. I ran across a couple of websites this week that are kind of interesting. The Mormon Church has a website, providentliving.org, Provident, living, Living, all one word, .org, and that's the official website of the Mormon Church, the Latter-day Saint Church. And they've got a lot of stuff on food storage and preparation for disaster-type stuff. As you recall, the Mormons always have a year's supply of food on hand, and basically a year's supply of everything. And they go through the whole drill and tell you how to do that. That is a website that's well worth looking at, providentliving.org. Okay, then, a second website that's kind of interesting is ready.gov, which is our official Department of Homeland Security, and they've got some stuff on preparation, and they talk about food and emergency kits and that kind of thing. Their website kind of tends to be, if you've gotten any good $20 books on preparation, they tend to be a little less in depth than some of those. But if you don't have one of those $20 books on preparation, this ready.gov is a good place to start. So I'd recommend that you go look at both websites and download them and get what information you can. James Lloyd, who is on shortwave every evening, you can also download him on the internet. He, through study of scriptures, was saying that basically the UN will move out of New York City and move to Jerusalem sometime yet this year. Don't know whether it's going to happen. You'll wait day by day to see what happens. But he's saying bad things are going to happen to New York City, so with a high probability of happening. So you just wait to see what happens. But go look at James Lloyd's website if you're interested in that kind of thing. Any questions or comments? James Lloyd has some real sobering things to say about New York City, Miami, and LA. I'm sorry, what? That it turned out that what people were telling you was a misquote of what he said. All he said was it had a high probability of happening based on scriptures. He didn't say it would happen. Yeah. High probability. Yeah. High probability. Yeah, that's right. You can't be wrong under those conditions. But also, we're in a net of prayer group and prayed to eliminate that. So he may well have been right, and we may have well prayed it away. If he was a good prophet, and we're good prayers, we prayed it away and destroyed his prophecy. That's right. That's right. Any other comments?
Okay. Any more announcements? Last week I was telling you about a gentleman in California that was dealing with the Federal Trade Commission, the courts, and a particular business that was in a trust. In that particular event I was telling you about, the FTC had literally taken him to court for an injunction, which they got the first temporary injunction to prevent him from doing with the business what he was doing. They set up a receiver for the business, and then as time went along, this gentleman did all the acceptances, and he accepted the facts as true. And once that had happened, he asked for settlement and closure. He eventually came back to the court, and they petitioned the court so that the receiver would step down, and all of the assets of the entity would come back to our buddy. The problem was they had gotten the FTC United States attorney in dishonor and had done a number of certificates of protest. They had those as exhibits when they filed their pleading with the court asking to get the assets back. They waited approximately 20 days, and lo and behold, I told you the judge came out with an order And the judge's order basically said that I can see no way in which the business can operate lawfully. Therefore, I'm going to issue an order giving permission for the receiver to sell all the assets of the business. Now, at the same time, this gentleman got a letter from the attorney for the Federal Trade Commission, and we talked about this last week. The letter was basically 3 paragraphs. The first paragraph, she started talking about the fact that the court has not gotten an answer to the complaint, which is over 4 months old, and she was telling them that the answer was late, and that if they didn't get it in, there would be a default judgment. The second paragraph talked about the facts that there were a lot of facts that had been in government discovery that they had not answered to, and she wants the answer to these facts. And the main fact dealt with the whereabouts and whether or not the trustee of the entity had any remaining property of the trust. The third paragraph was basically you've got 10 days to answer, and if you fail to answer in 10 days, particularly to where is the trustee, that we will move against you. They went ahead and put in a letter rogatory or response to her and filed into the court affidavit of negative averment, because what we suggested last week is that what the FTC attorney was really asking for was very simply to rebut the presumption that we haven't seen the true controlling head and we don't know who the equitable owner of the trust business really is. And because of that, the judge had given that judgment which said, we don't believe you can operate the business lawfully. In other words, the judge is saying, we have no evidence that you have control or equity in the business. So they rebutted that presumption. They even put an article, not an article, but an advertisement in the local legal newspaper asking the trustee to come forward, or the past trustee to come forward, and to put an affidavit into the court stating that he has not been a trustee or an owner of the company and has no assets of it since 1998. All those documents got put into the court. What is extremely interesting now is that subsequent to that, the woman attorney for the Federal Trade Commission wrote a new letter to our hero. And in that letter, it's very interesting, very short, very brief. It starts out, I received your latest Precipe filing, which you provided in response to my June 13, 2003 letter. I am returning the originals of the materials you sent to me. As an aside, is she starting to do acceptance and return to? It appears as though monkey see, monkey do. It's a mirror. If that is what you do to them, that is what they do to you. She goes on. It appears that you still have not filed an answer with the court, as required by the federal rules of civil procedure and the local rules for the Central District of California. If you do not file an answer with the court, the Commission will ask the court to enter a default judgment against you. Please file your answer with the court by such and such date, July 1st, 2003. Then she says, I will not be working on this case after July 1st. After that date, all correspondence should be sent to, and then they've got someone new. And then she signs this. What just happened? Well, she's going to get off the case. I don't think there's anything left in this case to deal with, to tell you the truth. I think it's pretty much settled. The only thing she is requesting is to file a pleading, an answer to the complaint. Now, we said last week in her previous letter, she talked about filing a pleading, an answer. But in reality, he's done an acceptance, he's done a return, and in the acceptance, it's a confession. All the facts in the pleading are accepted to be true. What happens if the prosecution goes in for a default judgment? What is the presumption that comes out of a default judgment? That you, A, didn't answer, B, you dishonored. Did this party, in fact, not respond? Well, he did respond. Did he respond in such a way that it was both procedural and substantive to help settle the matter? Yes. What happens in the presumption of a default judgment? What does the court assume and presume? No. It's not that you didn't answer. They're saying you didn't answer. Who cares? They could also say you're a liar, a cheat, and whatever else. What does the court, when the court moves forward, on what presumption after the default judgment is the court moving forward? They move forward on the presumption that the facts in the pleading are true. When you don't answer, what happens to the facts in the pleading? You assume that they are agreed to by the party, because you have a duty to respond and rebut. And if you don't answer, i.e. you don't respond, they will assume the facts in the pleading are true. Is that going to hurt our friend? Absolutely not. He already told them, I agree, the facts are true. Not only does he agree the facts are true, but he has proposed to them additional facts. But those may be on the private side. He asked, in a lot of cases, we have asked attorneys by letter rogatory to put those facts on the public side. Many times they do not. If they don't put them on the public side, whose fault is it that the facts are not on the public side? The attorney's. If the attorney has not followed through in his directions, he can be held liable for his actions in his dishonor to your draft. This court has been told of all of these facts, and basically this guy has said the facts in the charging instrument are all true. So if they come up with a default judgment and assume the facts are true, in this case with the FTC, the Federal Trade Commission, what is the court likely to do if they come up with a public judgment of default? What was the FTC asking for? Well, sell all the assets. The FTC was not asking to sell the assets. The receiver was asking to do that to consolidate the money. The FTC was asking for a permanent injunction. So if the court enters a default judgment with the assumption the facts are true, which our buddy admits, what will the court end up doing? Issuing a permanent injunction. That's what our buddy has asked the court to do for the last 2 months. Issue the injunction so I can accept it and we can close this matter. Because all the facts in the charging instrument were true. He admitted he had to correct his acts and actions. He wanted the permanent injunction so that he could accept it, tell them to close the case, then he can go in for post-judgment relief to get the assets of the corporation back, and he can go on with his life. Now, until we dealt with the letter last week, basically the letter that stated, but we don't know if you can run the business legally and lawfully, we hadn't seen that the court was looking to rebut the presumption as to who was the legal or lawful controller and owner of the company. Now that we have rebutted that presumption, if the government ends up putting out a permanent injunction, what is the government going to do with the assets? The government has not asked for a forfeiture. This is a civil case, not a criminal case. What the government was looking for is, to whom do the assets belong? Now that we have rebutted the presumption that nobody has appeared to ask for the assets, once the case is over, the government ought to bring the assets back to the owner, which is our buddy. So what came in the letter today is the backwards methodology of closing this case. This guy has been asking the court for the injunction, permanent injunction language so he could accept it, and the court has not given it to him. Now the United States Attorney is basically saying, geez, and if you don't come in and put in an answer, we're going to get a default judgment, which is going to automatically grant the permanent injunction, which will close the case, making it appear as though the public won, and then he can get his remedy. So it looks like, once again, everything is working perfect by going totally bad, according to what most patriots would look at the procedure and paperwork coming out of this case to be. But it looks like it's going to finish up just exactly like we believed it probably would. In other words, go into honor, help them settle the case, allow the straw man to appear to be the victim, allow the public to pat themselves on the head with all of the praise for once again resolving a major problem. They'll close the case down, and in post-judgment orders, you can get a remedy by petitioning the court for the return of the property. There's another case out there. I think we have been talking about the gentleman out west that has been in jail or prison for about 4 years and never been tried. He was held on charges in contempt for supposedly running investment program in Europe, sending money from clients in the United States overseas, bringing back supposed returns on those investments to pay off the clients what they were supposed to get. And the United States has claimed that it was a Ponzi scheme, and they shut this multi-million-dollar operation down as far as the United States was concerned. But there's been like $1 million a month coming back into this country from Europe on all the returns. Needless to say, they have been seizing that. Our hero in jail has not been tried because he's basically been arguing and dishonoring everything that's going on in the court. It turns out that there's not only a criminal case, but there is a civil case, again, I believe, by Federal Trade Commission or some other government agency. And that civil case is in Texas, and the criminal case, I believe, is in Arizona. Well, about 8-9 months ago, the gentleman that's in jail started learning about the acceptance and about going to honor instead of dishonor. And in those 9 months, he has started settling this case, and I believe we may have talked about a month ago, he went into a final administrative disposition on this matter with the United States prosecutor and also the magistrate judge. And we told you that the judge had said to him at the time that, I guess this is a state criminal case in Arizona, and we told you that the state of Arizona has provisions in their statutes that judges can set in on settlement conferences. And that's what this judge was doing. This judge asked the offender a number of questions. They got a settlement agreement. They had pretty much of a settlement agreement, at least in structure, as to the civil case. The judge entered the guilty pleading. This guy was charged with like 16 to 21 or more felonies. And he had accepted and returned all of those. And in a hearing in front of the judge with the prosecutor came back and said to him that, will you plead guilty to one of the felonies if we drop all the others? And this gentleman did not want to have any unfinished business out there and did not understand otherwise. So he said, no, I want to plead to all of them. And they said, well, I guess so. It's all right if that's what you want to do. But the way it has turned out, it was reduced, I believe, to 3 in their official books. And in those 3, then, that they accepted the pleading of guilty, last Friday he had to go back to this court for sentencing. He went back for sentencing, and before sentencing, like we have said in the past, there always is an interview with the probation department, because the probation department is writing a pre-sentence report, which is basically the dirty laundry of the straw man for all of his life, plus probably many inventions of evil deeds and tasks, whatever they can fill up the pages with, just to make you angry. And our hero had an interview, and he filled out a report for them. He answered all of the questions. He basically knew what they were looking for, and I'm not suggesting that he was merely answering the questions for the purpose of making it appear as though he wanted to play the game to get the relief. This gentleman now understands what the game is all about, and the game is honor. And you don't play the game to fake honor, because over the long run you won't be able to do that. Your actions will betray you. So he honestly answered the questions. He went before the judge. The sentencing hearing took about an hour and a quarter. During that time, the prosecutors said all kinds of evil, mean things. Also during that time, it turns out that the probation department officer there that put in his report was saying a lot of evil, mean things. It turns out that this gentleman had gotten oodles of letters from the so-called victims, every one of them praising this gentleman as being an honorable and a great guy. There were no so-called victims that appeared at the sentencing hearing at all for the purpose of explaining to the court how the acts of the straw man of this offender had caused him great grief and harm because of his acts. Most of the letters praised this guy as being a wonderful man and very honorable. Some of the letters went on to state that it was the government that was screwing everything up, not him. And the prosecutor made comment at the sentencing that this guy is such a fantastic con man that even his victims still to this day do not believe that he is an extortionist, a fraud, and a con man. And the prosecutor's position was that it was only because of the expertise and the cunning of the defendant that he had conned so many people and still is doing so even at this time. Now, what was interesting about this sentencing is there is kind of two versions of it, if you will. There is the public version, which goes on assumption, presumption, and conclusions for the benefit of the ignorant, fickle public. And then there is the true facts of what actually happened. What was interesting is that the public side was reported in a newspaper article for the Arizona Republic, and that article states as follows. A former carefree man who pleaded guilty to spending elderly investors' money on planes, luxury cars, and jewels was sentenced Friday to 17 1/2 years in prison. Then they named him, who has been jailed since October of 1999, agreed to plead guilty to 3 theft counts in exchange for the dismissal of more than 30 other charges. Admitting that, quote, mistakes had been made, unquote, the defendant asked for probation so he could try to repay about 300 investors more than $43 million he collected between January 1st, 1998 and March 15th, 1999. But Judge Gregg of Maricopa County Superior Court wasn't buying it. Quote, if this isn't an aggravated case, I don't know what is, unquote, the judge said, who once lived on a 10-acre spread in Carefree. Carefree is a town, obviously, in Arizona. Quote, this is so much money and the fraud is so gross, there just has to be a major sanction against you, unquote. The judge's the defendant's financial limited collapse, the company collapsed after a nearly 3-year investigation by the U.S. Securities and Exchange Commission. What they're really saying here is the business with no one at its head except the government receiver finally self-destructed. So after nearly 3-year investigation, it took that long to collapse it, the Arizona Corporation Commission, the U.S. Customs Service, and State Attorney General's Office, prosecutors said that the defendant promised to sink investors' money into a secretive European bank trading program, but spent it on 2 planes, a 31-foot cabin cruiser, jewels, and fat commissions for top salesmen, including a BMW. A certified public accountant appointed as the receiver in this case testified Friday that the money was never invested and the type of foreign investment the defendant promised doesn't exist. The seizure and sale of the defendant's home and other assets netted around $15 million. That includes the $1.5 million the defendant donated to the Church of Scientology, which handed over the money as part of a civil suit. About $12.5 million has been returned to investors. Gosh, they got back probably more than you'd think. Many of whom wrote the judge telling him that the defendant robbed them of their retirement money. Still, the defendant has many supporters. One of the gentlemen of Chandler who sold the defendant his 2 planes said in an interview that he invested $400,000 and was getting regular interest payments of $2,000 a month until the government shut down the company. Quote, if he ever gets out of this, I'd invest with him again, unquote, he said. But the judge said he wasn't convinced that the defendant's supporters understood that they were being paid by the money the defendant took from new investors. I feel for them, the judge said, of the defendant's supporters. End of the article. Now here is a kind of a transcript of what I got from some of the offender's friends. In open court today, the offender's straw man was declared guilty of 3 counts and was sentenced to 17.5 years in prison. What does 17 mean? Victory. What is 18? Bondage. So the defendant was somewhere between victory and bondage. That's a good spot, half and half. Defendant gets bondage, offender gets victory. 17.5 years. As he was leaving the courtroom, the offender signed 3 documents for the straw man in the usual way, accepting them for value, etc., and was taken back to his cell at the detention center. One of the papers was simply noticing him that he had no right to appeal, but could petition the court for post-conviction remedy. The other document was entitled Judgment and Orders of Restitution, Fees, and Fines. He was statutorily eligible to receive a fine of up to $150,000, but received only a mandatory fee of $20 on the paperwork. Remember, this is private. This is not going out to the newspapers. This was not mouthed off verbally in the court. The text reads, quote, reinstatement commencing blank, unquote. There is no commencing time. And we are not sure what this thing means, but it appears to be a draft for $20 plus the restitution amount claimed by the receiver. There is a checklist which says, case type, new, modified, reinstatement, Department of Correction release, or other. Nothing is checked. The third document was called Uniform Conditions of Probation and reads as follows. Quote, "It is the judgment of this court that the defendant is guilty of count 2." Unquote. That count only carries with it probation, no jail time. Quote, "It is ordered suspending imposition of sentence and placing the defendant on probation under supervision of the Adult Probation Department for a period of 7 years under the following conditions." Unquote. Suspending imposition of sentence, didn't the judge say 17 and a half years in open court? But on the paperwork, it is ordered suspending imposition of sentence. The date probation is to begin was left, quote, "to be determined," unquote. Then in the judge's handwriting are the words, quote, "absolute discharge from prison sentences," unquote. There follow a great many pre-printed words detailing conditions, only 2 of which were checked, and the judge's signature. So after thinking we got the ultimate maximum, it seems that we didn't. Everyone who left that courtroom, including the defendant, was convinced by the public spectacle that the straw man received the worst possible sentence. The judge even said that on top of the maximum, he was ordering counseling and community service for when the defendant got out of prison, implying that the defendant was mentally unfit and kept asking the defendant a lot of unpleasant questions in the sentencing hearing. No one the defendant was involved with would testify against the defendant in the sentencing hearing. So the only antagonistic witness was the receiver, the one appointed to take control of all the assets of the now defunct corporation. And it's the receiver's job to be nasty, so that was okay. The prosecutor said the defendant is a con man, and he's too good. A lot of people still believe in him. That's why the judge got so many nice letters about him. The offender's single most important piece of property, his body, is still being held, but as much as I analyze the 3 documents, it seems to be good news. We are awaiting developments, and any insight or experience you may have is appreciated. Now, we do not know what the outcome of this is going to be yet. I don't know if I reported this. I believe I did, but my friend Nick Groshinen in Idaho, when he went in and pled guilty on his one case, the prosecutor had promised that there were other charges that would be discharged or dismissed. Nick never appealed the conviction. And after 30 days after sentencing, which he could have put in an appeal on some issue, but he elected not to. He got a letter in the mail from the prosecutor 3 days after the 30 days was up. And it was a notice from the prosecutor of a filing into the court instructing the court to dismiss the other unprosecuted charges.